First of all, we need to get everybody to understand that the architecture and design of Article 146 of the Constitution of Ghana 1992 was intended to protect justices of the Superior Court of Judicature and chairman of the and chairman of regional tribunals.
Okay.
That's the first thing. So from Article 1461 to the last provision of that article are checks on the powers of the president, so that you can, and a capricious, willful president cannot at will remove a justice of the Superior Court of Judicature. And the Chief Justice is a justice of the Superior Court of Judicature. So you have institutional limitations on the exercise of that power. You have procedural limitations on the exercise of that power. And you have substantive limitations on that power. So, and I have said time and again that for you to understand the remit of Article 146 and what it was intended to do, you need to go back to the 1969 Constitution.
Okay.
It is the 1969 Constitution that established the Council of State and said that an individual in this country, a citizen of this country, who is dissatisfied with the way the Chief Justice or justices of the Superior Court of Judicature are going about their duty, and who thinks that the conduct falls within Article 1461, can invoke the authority and power of the president to subject that conduct to inquisition. So we must all understand that. And so it is important for anybody who is interested in safeguarding the rights of the justices of the Superior Court of Judicature and the independence of the judiciary to follow through the provisions of the Constitution and see whether the fidelity of the provisions of the Constitution have been given effect to or have been obeyed.
Have they been given effect to?
So let's track it.
Go ahead.
The Bar Association of the Republic of Ghana said in their first release that nothing untoward, they have not seen a breach of the provisions of the Article 146 of the 1992 Constitution.
Mm.
The Bar Council of England and Wales, in their long letter to the President demanding the restoration of the Chief Justice, have not pointed out one breach of the provisions of the 1992 Constitution, and particularly Article 146. The Commonwealth Lawyers Association, who joined the Bar Council of England and Wales, did not indicate or point out or state that Article 146 has been violated.
Okay.
Legal experts in this country are unanimous in saying that Article 146 has not been violated. The adequacy or otherwise of Article 146 will be a conversation on its own.
Okay.
But for now, we say that Article 146 has been followed through. The President has followed all the checks on his power, and he has, under Article 146(10), relieved the Chief Justice of her responsibilities as a Chief Justice and also a Justice of the Superior Court of Judicature.